Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the property order attachment to judgment form, also known as FL-345. As with all our court forms, you want to fill in your identifying case caption information at the top. This is going to be submitted as part of a judgment. You obviously have the right to write out the terms of either what was ordered or what you are agreeing to with respect to division of assets and debts in your judgment. But this form is a form that you can use to just make it a little bit easier as to what sort of information needs to be included and provided as part of the judgment. So the first line addresses the division of community property assets. If there are no community property assets, and again, those are assets that are acquired during the marriage, then you would mark the box that says 1A. If you do happen to have a hearing or trial and the court finds that the net value of the community estate is less than $5,000 and the other party cannot be found and thereby awards the entire estate to you, then you can mark box 1B and identify the box that correctly marks the other party that can't be found and who the entire estate is being awarded to. In line 1C, you're going to list the assets that are being awarded to the petitioner. In line 1D, you're going to list the assets that are being awarded to the respondent. If this is not enough space, you're welcome to attach an additional page if necessary. If there is a retirement account and the court orders that it is to be divided using a qualified domestic relations order, then you would mark box 1E and identify the party who's responsible for preparing that qualified domestic relations order. It can be one or the both of you, and identify which accounts are subject to that order. And then there's always a fee for preparation of what's called a quadro, and so you would list how that fee is to be shared. If there are any orders regarding the division of assets, you would list those under 2 or 1F. And then 1G is just stating that, and you'd mark this box, that any of the assets that are awarded above now become the party to whom it's awarded their sole and separate property, and that each party has to execute any documents necessary to carry out this division. Below, we have the division of community property debts. As with the assets, if there are no community debts, you want to mark box 2A. If the court finds that the debts have been paid by one party and the other party has an obligation to reimburse that party certain monies, then you would mark box 2B, identify the party that paid the debts and the party that has to reimburse the other, and list the total amount to be reimbursed. If the court sets a payment plan for how that reimbursement is to be paid, you would describe that under the payment plan is as follows. If, on the other hand, the court or you guys agree to just assign certain debts to the parties, then you would want to fill in 2C, which states which debts the petitioner is going to be responsible for, and you would want to list those under here. And again, you can attach an additional page if necessary. And then 2D is where you would list the debts that the respondent is being assigned. If there are any other orders regarding the debts, you would list those in 2E. And 2F is just stating that whomever a debt is assigned to is going to hold the other party free and harmless from that debt. If there is, after the total division of assets and debts, an equalization payment ordered, you would want to mark box 3. Understand that it is the court's intent that each party walk away with an equal value of assets and debts. That's not always possible. You can't always divide an asset into half and give each party exactly half. So a lot of times the courts will put certain assets and debts being awarded to one party versus the other, and it's not always a clean break down the middle. So if one party gets more value than the other, then the court will likely order what's called an equalization payment, and that just means that one of the parties has to pay certain monies to the other party to ensure that both parties walk away with equal value. So again, if an equalization payment is ordered, mark box 3, mark the box that correctly identifies the party who owes the equalization payment, the amount of the equalization payment, and if the court sets a payment schedule, then you would list that below how that's to be paid. In field 4, we are dealing with separate property. And again, separate property is generally property that is acquired before marriage, after separation, or by inheritance or gift. So if the court awards any property as the sole and separate property of the petitioner, you would list that in 4A and list what those assets and debts are. And if the court confirms any separate property to the respondent, you would mark box 4B and list what those assets and debts are. If the use of this form is merely to just adopt the settlement agreement, if there is a written settlement agreement between the parties, you can always mark box 5, list the date of the settlement agreement, and this is just saying that this is now part of the judgment. If the court orders the sale of any property, or that's a term that the two of you are agreeing to, mark box 6, and this just describes how the proceeds from the sale will be divided either equally, or if there's some other division under other, you can specify what that is. And then under other orders, if there's any other orders related to the assets and debts of this marriage, then you would list those in 7. You then attach this to your judgment packet, and it is ready to submit to be processed. I hope you found this helpful. Good luck.